Always consider whether you need permission to appeal, even if you've won your client's case. You've won in the first tier tribunal. Your client's delighted with you. Fantastic. It's a great result. But before you rush out and celebrate, there's a couple of things you need to think about. Firstly, the Home Office can appeal against the decision within 14 days if your client is in the UK, and you can be taken to the Upper Tribunal, who can overturn that decision. Secondly, look carefully at the determination. If the tribunal has allowed your client's appeal on one ground but dismissed it on the others, what you need to think about is whether the dismissed grounds of appeal would have left your client better off than the ground on which the tribunal has allowed the appeal. This is the key point coming out of a recent case called Smith. It's a reported case of the Upper Tribunal in which I represented the appellant. In summary, the Upper Tribunal will expect you to seek permission to appeal if any of the dismissed grounds of appeal would have led to a better outcome for your client than the ground or grounds on which the appeal has been allowed. So in Smith, my client had won on his European Union law ground of appeal, but had lost on his human rights Article 8 ground of appeal. There was no point in him applying for permission to appeal against his dismissed Article 8 ground because he had already succeeded in establishing a right of permanent residence under European Union law, which was better for him in his circumstances than seeking to obtain a chunk of 30 months leave under human rights law. However, he got taken to the Upper Tribunal because the Secretary of State applied for permission to appeal against his successful European law appeal. We ended up going into the Upper Tribunal and trying to challenge the dismissal of his Article 8 ground of appeal by way of what's called a Rule 24 response, so a response to the Secretary of State's grounds of appeal. Could we do that? Well, fortunately, the tribunal answered that question, yes. The tribunal accepted our arguments that in order for the tribunal system to function practically and keep the administration of justice going, it should discourage academic appeals. Where there would be no advantage to a claimant or an appellant seeking permission to appeal, they shouldn't be expected to do so. Thankfully, despite not having any permission to appeal, we were allowed to challenge the dismissal of my client's Article 8 appeal. So hopefully Smith clarifies when you need to seek permission to appeal. Again, don't celebrate too fast when you win appeals. Look carefully at the determination and see whether or not you should be advising your client to actually, although they've won, to counterintuitively seek permission to appeal against the unfavourable parts of that decision.